If you have real estate in your own name and you get a divorce, maybe there's multiple real estates, maybe there's a vacation home that you use for Airbnb purposes or a lake house or something like that. Does that mean that your ex is going to get any of them in a future divorce? Well, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. Today we're going to continue our video series. It's designed to educate and inform the public, so please subscribe to our channel. So what's the scoop with how we handle vacation homes or lake houses or Airbnbs if they're only in your name? Well, I think when a lot of people ask me this question, and remember, a lot of our video content comes from questions that the public addresses to us. When people ask this question, I think they're getting a little distracted by the fact that it's a lake house or it's an Airbnb or a vacation home. The truth of the matter is that the title of the property or how it's used is really not part of the equation. The question is, when was it acquired? If your real estate was acquired during the marriage, even if it's in the name of one spouse only, the issue is not in whose name it is. The question is when. If it was acquired during the marriage, it is marital property. And because it's marital property, irrespective of the title, it's going to be subject to division. It's going to be in play, which means there's going to be a reckoning, and there's going to be marital apportionment of that Airbnb or that lake house. It's going to be half to one and half to the other. Now, we may not sell them. We may not have to do that. You can't cut them in half. We might say, for example, that one person will keep the lake house because it's worth $1 million. The other person won't have that house, but that $500,000 that they lost, they're going to get more of the 401k money. They're going to get an increase in that so that we're even at the end. These are possibilities. So my point is that we don't always have to liquidate the item, but they will be part of the mix. And we will reconcile that item as we would any other piece of property, even if it's an Airbnb or a lake house. Airbnbs are interesting because you might not want to liquidate that because it's probably generating money and it may be self-sustaining. In other words, it may be enough money to pay for the mortgage and pay for this and pay for that. So maybe the idea is that since that's not really a debt, that's a growth and income investment, maybe it makes sense to maintain it up to a certain amount of time so that in the future the kids can have it to use, and maybe we split the money or we do something else, and obviously the lawyers could assist in the parties knowing how to handle that. But these are certainly considerations that have to be brought to the forefront as we decide what's the fair and equitable way to divide these assets. If you have any questions about that, reach out and we'll be glad to help you out.